Hello and welcome back to Customs and GST Advisory channel of Customs GST.com. I am delighted to welcome you once again to the channel, where we break down complex customs and GST issues into practical, legally accurate, and professionally useful insights. Do subscribe and like it for more insights and engrossing topics. In today's video, we are discussing a very important and powerful topic. 10 reasons why a customs show cause notice may be void, invalid, or legally unsustainable. Now let me make one thing clear at the very beginning. In strict legal language, not every defect will always make the show cause notice, void ab initio in the same sense. Some defects strike at jurisdiction, some destroy the extended period, some make the valuation enhancement fail, some lead to remand, and some make the final order unsustainable. But the larger message remains the same. No law, no evidence, no valid demand. So in this video, we will go reason by reason, and for each reason, we will connect it with the best matching judicial ratio. Let us begin. The first and most fundamental defect is lack of jurisdiction. If the officer issuing the show cause notice is not the proper officer in the eye of law, then the entire proceedings can collapse at the threshold. The leading authority here is Canon India, Private Limited versus Commissioner of Customs. The Supreme Court held that the power to reopen and issue notice under Section 28 cannot be exercised by just any officer. The officer must be the proper officer, legally empowered for that very function. The court reaffirmed the principle flowing from Said Ali case that only an officer legally entrusted with assessment-related functions can issue a valid demand notice under Section 28. In other words, jurisdiction is not a technicality. It is the foundation. So if the notice is issued by an officer who lacks statutory authority, the defect is not cosmetic. It goes to the root. And once the root fails, the proceedings fail. The second reason is proceedings without legal authority by the adjudicating official. This is closely connected to jurisdiction, but slightly broader. Even where an officer exists within the customs framework, he still cannot act beyond the power actually entrusted by the statute. Again, Said Ali and later Canon India are the best authorities. The Supreme Court's reasoning is clear. The Customs Act is a statute of powers, and statutory powers must be exercised only by the authority to whom the law gives them. If one authority assumes the role of another without proper entrustment, that exercise is ultra vires the act. So the message is simple. Public power must come from the statute. If the power is not vested, the proceeding is not merely weak, it is unauthorized. The third major reason is limitation. Under customs law, if the department wants to go beyond the normal period and invoke the extended period, it must specifically allege and support the ingredients such as willful misstatement, collusion, or suppression of facts. A very strong and closely matching authority is Aban Lloyd-Childs, Offshore Limited versus Commissioner of Customs. The Supreme Court held that if the show cause notice does not specifically state which omission or commission justifies the extended period, the assessee is deprived of a fair chance to meet the case. The court further held that where the department already knew the facts, it could not invoke the extended period. The demand beyond the normal period was held to be beyond limitation and was quashed. So, a time-barred demand cannot be rescued by vague allegations. The fourth reason is one of the most practical and most litigated grounds. A customs demand cannot survive on suspicion alone. This is especially important in valuation matters. The Supreme Court in South India Television, as later reiterated in Rabindra Chandra Paul, held that the invoice price cannot be rejected merely on suspicion. The department must gather proper material, such as evidence of comparable imports or other cogent evidence of undervaluation. The court specifically said that casting suspicion on the invoice is not enough, and that undervaluation has to be proved. If that evidence is absent, the benefit of doubt goes to the importer. So if the notice says, "We suspect the value is low," but produces no convincing material, then the allegation is only a suspicion, and suspicion is not evidence. The fifth reason is violation of natural justice. A person cannot effectively answer a notice unless he knows the case against him and gets access to the material relied upon. A very clear Supreme Court articulation of this principle appears in Titacano versus Sebi of 2022 decision. Though not a customs case, the principle is fully applicable to quasi-judicial proceedings, including customs adjudication. The court held that a quasi-judicial authority has a duty to disclose relevant material, relied upon including an investigation report for adjudication, and if the authority reveals only minimal information to the prejudice of the noticee, it violates natural justice. The court emphasized that relevant material necessary for an effective defense must be disclosed. So if relied upon material is withheld, or if the noticee is denied a fair opportunity, the defect is not procedural trivia. It hits the very fairness of adjudication. The sixth reason is that the show cause notice itself is vague, non-specific, or unintelligible. The best matching authority here is Commissioner of Central Excise versus Brindavan Beverages Private Limited. The Supreme Court held that the show cause notice is the foundation of the department's case. If the allegations in the notice are not specific, are vague, lack details, or are unintelligible, that itself is sufficient to hold that the noticee was not given a proper opportunity to answer the case. In short, a notice must tell the importer clearly what is alleged, on what basis, for which period, under which provision, and supported by what material. If it does not do that, the foundation itself is defective. The seventh reason is when the adjudicating authority goes beyond the allegations contained in the show cause notice. The principle is well settled. An adjudication order cannot travel beyond the show cause notice. The show cause notice is the boundary line of the dispute. The authority cannot confirm the demand on a new ground that the notice never put to the importer. For this proposition, authorities commonly relied upon include Toyo Engineering India Limited and similar excise customs, jurisprudence on the rule that the notice is the foundation of adjudication. If the notice alleges one case, but the order confirms another case, then the assessee is condemned on a ground he was never asked to meet. That is impermissible in law. The eighth reason is very important in the matter of customs-specific point of valuation. If the department wants to reject a declared transaction value, it cannot do so casually. The law requires a disciplined route. The jurisprudence flowing from Supreme Court decision in Aisha Tractors, South India Television, and also later valuation decisions makes it clear that the transaction value is the primary basis. Before discarding it, the department must have cogent reasons. Under the Rule 12 of Customs Valuation Rules, 2007 framework, the proper officer must first have reason to doubt the truth or accuracy of the declared value, and then proceeded in accordance with law. Only after rejecting transaction value can the authority move sequentially to later valuation rules. The Supreme Court has repeatedly said that if Rule 4 transaction value is acceptable, there is no question of directly jumping to subsequent rules. So if Rule 12 discipline is not followed, the rejection of transaction value itself becomes vulnerable. And when rejection fails, the enhancement fails. The ninth reason is a more specific version of reason number 4. Where the department alleges undervaluation, it must ordinarily show contemporaneous imports of identical or similar goods or some equally reliable comparative evidence. The Supreme Court, in Rabindra Chandra Paul, relying on South India Television, clearly observed that before rejecting invoice price, the department must find out whether there are imports of identical or similar goods at a higher price around the same time. In the absence of such evidence, the invoice price must be accepted. The court also said that the burden does not automatically shift to the importer, merely because the department is doubtful. So where there is no contemporaneous evidence, no comparable imports, and no reliable valuation basis, the transaction value normally stands restored. The 10th reason is the issue of mechanical show cause notice. A valid show cause notice must reflect application of mind. It cannot be a template, a cut and paste accusation, or a pre-decided conclusion disguised as a notice. On this point, one of the most cited authorities is Oryx Fisheries Private Limited versus Union of India, where the Supreme Court disapproved notices that virtually disclosed a closed mind. The broader natural justice logic is also reinforced by Tita Kano. The notice must be fair, informed, and supported by relevant disclosed material. A prejudged or mechanically issued notice undermines the process itself. A show cause notice is not supposed to be a conviction notice. It must invite explanation, not announce guilt in advance. The first situation in lack of territorial jurisdiction reason is, suppose an import or export transaction falls within the jurisdiction of one customs formation, but the show cause notice is issued by an officer who has no territorial connection or legal assignment over that transaction. For example, the transaction belongs to one port, one customs commissionerate, or one notified territorial area, but the notice is issued by another authority without legal empowerment. Under customs law, powers are not floating powers. They are traceable to the Customs Act, notifications, administrative assignments, and statutory functions. Sections 4 and 5 of the Customs Act deal with appointment and powers of customs officers. Therefore, territorial and functional authority must be traceable to law. The practical defense is simple. Show me the legal source of your jurisdiction. If the officer cannot show the legal source, the SCN becomes vulnerable. The second situation is where the officer exists in the Customs Department, but is not empowered to perform the particular statutory function. This distinction is very important. Every officer of customs is not automatically competent to exercise every power under the Customs Act. An officer may be senior in rank, but rank alone does not create jurisdiction. What matters is assignment of function. The issue is not, is the officer senior? The issue is, was this officer legally empowered to issue this particular notice under this particular provision? For example, a show cause notice under Section 28 for short levy or non-levy must be issued by the proper officer. The phrase proper officer means an officer who has been assigned that function under law. Therefore, the defense is not based merely on designation. It is based on legal authority. The key line for the audience is rank is irrelevant. Authority is key. The third situation arises when a statutory notification assigns a function to one authority, but another authority assumes that function without legal basis. This is a classic jurisdictional defect. Suppose a notification assigns a particular class of cases to Commissioner A, but Commissioner B issues the notice. Or suppose an officer relies on general departmental convenience instead of the actual notification, assigning powers. That is not permissible. In customs law, jurisdiction usually flows from the Act, notifications, circulars, orders of assignment, and statutory delegation. If the statute or notification points to one authority, another authority cannot simply assume that role. A department cannot say, "We handled the investigation, therefore we can issue the notice." Investigation and adjudication power are not always the same. Collection of intelligence and issuance of a statutory SCN are different steps. Each step must be backed by law. The principle is functions assigned by law cannot be assumed by administrative choice. The fourth situation is exercise of power beyond delegation. Many times, customs officers act under delegated authority. That delegation may be limited by value, subject matter, class of goods, nature of offense, territorial area, or specific statutory function. If an officer has authority only up to a certain monetary limit, or only for a certain category of cases, or only for a certain type of function, he cannot exceed that delegation. For example, if the delegation allows action up to a specified monetary threshold, and the officer issues a notice for a matter beyond that threshold, then the importer can question the competence of the officer. When the statute or notification limits power, crossing that limit can affect jurisdiction. The voice of the law is clear. Delegated power must remain within the boundary of delegation. An officer cannot expand his power merely because the case is serious, the demand is large, or the department believes action is necessary. The fifth situation is absence of jurisdictional facts. This is a very important but often overlooked concept. A jurisdictional fact is a fact that must exist before the authority can exercise a statutory power. For example, before proposing confiscation, there must be facts that bring the goods within the relevant confiscation provision. Before invoking a particular demand provision, there must be facts that trigger that provision. Before alleging misdeclaration, undervaluation, improper import, or violation of condition, there must be foundational facts. If the foundational facts are absent, the power itself may not arise. This means that the department cannot first assume power and then search for facts later. The correct sequence is: first, the jurisdictional facts must exist. Then, the statutory power may be exercised. So the defense question is, what jurisdictional fact existed on the date of the show cause notice? If the answer is unclear, the show cause notice becomes open to challenge. The sixth situation is where proceedings are initiated under the wrong provision. Customs law contains different provisions for different situations. A demand for duty, confiscation of goods, penalty on persons, recovery of interest, reassessment, provisional assessment, and post-clearance action are not the same. Each provision has its own conditions, limitations, safeguards, and consequences. If the department uses the wrong provision, it may not be a simple drafting mistake. It may go to jurisdiction. For example, if the factual situation is governed by one statutory route, but the department invokes another route that does not legally apply, the notice may suffer from want of jurisdiction. The legal point is wrong provision can mean wrong power. Wrong power can mean no jurisdiction. Therefore, every show cause notice must be checked provision by provision. Ask which section is invoked. Does that section apply to these facts? Are the statutory preconditions satisfied? Has the correct officer invoked the correct provision? This is how jurisdictional defense is built. The seventh situation is one of the strongest principles in law. Jurisdiction cannot be created by consent. This means that even if the importer replies to the notice, attends personal hearing, participates in investigation, submits documents, or argues the matter on merits, that participation does not automatically give jurisdiction to an officer who had none. There is no waiver of inherent lack of jurisdiction. Consent cannot create statutory power. Participation cannot cure absence of power. Silence cannot validate an authority that the statute never empowered. This is why jurisdictional objections should be taken clearly and at the earliest stage. But conceptually, lack of jurisdiction is a root defect. The key line is, no agreement, no participation, no hearing can create jurisdiction where the law has not conferred it. The eighth situation is administrative convenience. In large customs investigations, the department may centralize intelligence, coordinate between multiple ports, or allow one unit to collect information from several places. That may be administratively useful. But administrative convenience is not the same as statutory jurisdiction. A centralized investigation may help the department gather evidence, but the power to issue a statutory show cause notice must still come from the Act and the relevant notifications. The department cannot say this was convenient, so this officer issued the notice. Convenience is not jurisdiction. Coordination is not jurisdiction. Investigation is not automatically adjudicatory competence. Therefore, the importer must ask, was the officer legally assigned? This function, was the officer empowered? For this case, was the officer competent? On the date of issuing the CN, the principle is administrative convenience cannot replace statutory authority. The ninth situation is timing. Jurisdiction must exist on the date when the show cause notice is issued. A later notification, later assignment, later administrative order, or later explanation may not always cure a defect that existed at the inception, unless the statute specifically validates the past action. This is important because the legality of a notice is generally tested with reference to the date of its issuance. So, when examining an SCN, do not only ask whether the officer has power today. Ask, did the officer have power on the date of issuing the CN? Was the relevant notification in force on that date? Was the officer assigned that function on that date? Was the territorial or subject matter jurisdiction available on that date? The key line is, jurisdiction must exist at inception. Later events cannot casually cure an original lack of power. Let us now summarize the key legal principle. Jurisdiction is the statutory authority to decide, unless the Customs Act, 1962, read with the relevant notifications and assignments, confers power upon the officer to initiate proceedings. The show cause notice lacks legal foundation. Jurisdiction is a condition precedent to the valid exercise of power. It cannot be supplied by consent. It cannot be supplied by participation. It cannot be supplied by administrative convenience. It cannot be supplied merely by the seriousness of the allegation. It must exist in law, and it must exist on the date of issuing the show cause notice. Let us first understand the distinction between reason number 1 and reason number 2. Reason number 1 is lack of jurisdiction. It asks, did the authority have jurisdiction over the case itself? For example, did the officer have territorial jurisdiction, subject matter jurisdiction, or statutory authority to deal with that category of case? Reason number 2 is different. It asks, even if the case was within the customs framework, did the officer exercise a specific power that was actually entrusted to him? So, reason number 1 asks, who may deal with the case? Reason number 2 asks, what powers has the law given to that officer? This distinction is very important, because in statutory law, especially under the Customs Act, 1962, there is no such thing as general unlimited power. Every coercive action must be traced to a specific provision. A show cause notice is not merely a letter. It is the beginning of serious legal proceedings. It may demand duty. It may propose confiscation. It may propose penalty. It may allege suppression, misdeclaration, undervaluation, or wrongful import. Therefore, the officer issuing such a notice must show the statutory source of power. The core principle is, statutory power is not assumed, it is conferred. The first point is that every power must come from law, not from rank, not from investigation, not from departmental convenience, not from internal pressure, not from seriousness of allegation. Only law can give statutory power. If the Customs Act, rules, notification, circular, assignment order, or statutory delegation does not confer the power, then any officer cannot exercise it merely because he is connected with the case. This is why, when a customs show cause notice is received, one of the first questions should be, which legal provision empowers this officer to issue this notice? A general reference to the Customs Act is not enough. The department must be able to show the exact chain of authority. The officer was appointed. The officer was assigned the function. The officer was competent for that provision. The officer acted within the scope of that assignment. If this chain breaks, the notice becomes vulnerable. The second point is that the statutory source is mandatory. In customs proceedings, words like proper officer, commissioner, additional commissioner, assistant commissioner, or deputy commissioner are not decorative words. They define competence. For example, where the act requires action by a proper officer, the question is not merely whether the person is a customs officer. The deeper question is, was he the proper officer for that statutory function? A person may be an officer of customs, but unless the relevant function is assigned to him, he may not be the proper officer for that action. This is why the issue of proper officer has created major litigation under customs law. The lesson is clear: designation is not enough. Assignment of function is essential. Therefore, while examining a customs show cause notice, check which section is invoked, who issued the notice, what notification empowers him, what assignment gives him that function. Was the assignment valid on the date of notice? This is the statutory source test. The third point is that delegated power cannot be expanded. Many officers act under delegated authority. Delegation may be limited by territory, subject matter, monetary limit, class of goods, type of proceeding, nature of function, or period of time. If the law delegates power for one purpose, the officer cannot use it for another purpose. If the notification delegates power within a limit, the officer cannot exceed that limit. If the assignment is for investigation, it does not automatically mean power to issue every kind of show cause notice. If the assignment is for one statutory provision, it cannot automatically be stretched to another statutory provision. In other words, a delegated power must be strictly followed. The officer cannot say, I had some power, therefore I had all power. That is not how statutory competence works. A statutory authority is like a key. It opens only the lock for which it is made. It cannot open every door. So, if an officer uses the wrong power, exceeds the delegated power, or acts outside the statutory condition, the action can be challenged as being beyond statutory competence. The fourth point is very practical. In customs matters, many cases involve multiple ports, multiple importers, multiple consignments, multiple bills of entry, and multiple investigating units. For administrative convenience, the department may centralize investigation. One formation may collect documents. Another unit may record statements. A specialized unit may analyze data. A coordinating office may prepare a case report. All this may be administratively useful, but administrative convenience is not statutory power. Convenience cannot create jurisdiction. Coordination cannot create competence. Investigation cannot automatically create adjudicatory authority. A serious allegation cannot create power. Even if the department says, this officer handled the investigation, the legal question remains, was this officer legally empowered to issue this SCN under the Customs Act? If the answer is no, then administrative convenience cannot cure the defect. This is very important for importers and consultants. Never confuse departmental convenience with legal competence. The fifth point is timing. The officer must have statutory competence on the date of action. If a show cause notice is issued today, the officer must have power today. A later notification, later clarification, later administrative order, or later assignment may not automatically cure an earlier lack of power unless the law clearly validates past action. Therefore, the date of the show cause notice is crucial. When you examine a notice, ask, on the date of the show cause notice, was the officer appointed as a customs officer? On the date of the show cause notice, was the officer assigned the relevant function? On the date of the show cause notice, was the officer competent under that provision? On the date of the show cause notice, did the notification cover this case? On the date of the show cause notice, were the statutory conditions satisfied? If competence did not exist on the date of action, then the notice may be attacked as legally unsustainable. The principle is, no ratification, no waiver, no cure, unless the statute itself clearly provides it. Now, let us connect this concept to the phrase, power without authority is invalid. This is a powerful line. A customs officer may have institutional power, but legal power is different. Institutional power means the officer belongs to the department. Legal power means the statute authorizes that officer to act in that specific manner. A statutory proceeding survives only when institutional position and legal authority come together. If the officer has office but not authority, the proceeding becomes vulnerable. If the officer has information but not power, the proceeding becomes vulnerable. If the officer has suspicion but not statutory competence, the proceeding becomes vulnerable. The foundation is always law. Let us now understand this through a simple example. Suppose an officer is empowered only to investigate. He collects documents, records statements, and prepares a report. But the law requires the show cause notice to be issued by a proper officer assigned under a particular provision. If the investigating officer, without proper statutory assignment, issues the SCN himself, the importer can ask, where is the legal entrustment? Another example. Suppose a power is delegated only up to a particular monetary limit, but the officer issues notice for a demand beyond that limit. The importer can ask, did the officer act beyond the monetary limit of delegation? Another example. Suppose a notification assigns a function to one class of officers, but another class of officers exercises that function without valid assignment. The importer can ask, can a statutory notification be bypassed by administrative convenience? The answer is no. The department must act within the statute. Now comes an important caution. Do not make a careless or mechanical argument that every notice by a particular agency is void. That may not be legally safe, especially after later amendments, notifications, and judicial developments. The correct argument is more precise. Show me the statutory source of power. show the appointment, show the assignment, show the notification, show the provision, show the territorial competence, show the subject matter competence, show that all this existed on the date of issuing the SCN. This is the correct and professional way to challenge statutory competence. The challenge must not be emotional. It must be documentary. It must be provision-based. It must be notification-based. It must be date-specific. When the department issues a customs show cause notice after the legal time limit has expired, this is not a small technical objection. This is not a mere procedural point. This is a jurisdictional barrier, because once limitation expires, the authority loses the statutory power to demand duty, unless the law itself permits extension on clearly defined grounds. The key message is demand without time, limit is power without authority. Let us understand this under Section 28 of the Customs Act, 1962. Section 28 deals with cases where customs duty has not been levied, short levied, not paid, short paid, or erroneously refunded. But the law does not give unlimited time to the department. The law creates limitation periods. There is a normal period. There is an extended period. And the extended period is not available in every case. It is available only when the short levy or non-levy is because of serious statutory ingredients such as collusion, willful misstatement, or suppression of facts. These are not decorative words. These are jurisdictional facts. They must be specifically alleged. They must be supported by material, and ultimately, they must be proved. On one side, we have normal limitation. Normal limitation applies where there is no fraud, no collusion, no willful misstatement, and no suppression of facts. In such cases, the department must issue the show cause notice within the prescribed normal period. If the notice is issued after that period, and there is no valid ground for extended limitation, then the demand becomes time-barred. On the other side, we have extended limitation. Extended limitation is a longer period, but it is not automatic. The department cannot simply write the words suppression of facts and claim extended limitation. The law requires something more. There must be a positive act or omission. There must be material showing that the importer suppressed facts, made a willful misstatement, or acted in collusion. A mere mistake is not enough. A valuation difference is not enough. A classification dispute is not enough. A different legal interpretation is not enough. A subsequent audit objection is not enough. A later change of view is not enough. If the department wants extended limitation, the department must prove the statutory ingredients. These are statutory facts that must be proved. This is a very important line. In a Customs N, extended limitation is not just a paragraph. It is a legal gateway. If the gateway fails, the demand beyond the normal period fails. That is why, when you receive a customs show cause notice, always check the limitation paragraph carefully. Ask these questions. When was the bill of entry filed? When was assessment completed? When was the duty allegedly short paid? When was the show cause notice issued? Is the notice within the normal period? If not, what is the exact basis for extended limitation? Does the notice merely use words like suppression and willful misstatement? Or does it actually explain what was suppressed, when it was suppressed, how it was suppressed, and how the department discovered it? This is where many customs demands become legally vulnerable. Insufficient or unreliable evidence. Show cause notice without legal foundation. This is one of the most important principles in customs adjudication. A customs show cause notice cannot be built on suspicion. It cannot be built on assumption. It cannot be built on conjecture. It cannot be built on unverified data. It cannot be built on uncorroborated statements. It cannot be built on incomplete analysis, because in law, allegation is not evidence, suspicion is not evidence, and departmental belief is not proof. The key message of this video is, no proof, no case, no power. Let us begin with the basic principle. A show cause notice is not just a departmental communication. It is the foundation of adjudication. It can lead to demand of duty, confiscation of goods, redemption fine, penalty, interest, prosecution exposure, and business disruption. Therefore, the law expects the department to issue an SCN only when there is credible material. The department cannot say, "We suspect undervaluation. We think classification is wrong. We believe the importer has misdeclared. We assume there is suppression. We received intelligence." These may be starting points for inquiry, but they are not substitutes for evidence. Investigation may begin with suspicion, but adjudication cannot end with suspicion. Suspicion is not evidence. This principle is extremely important in customs valuation cases. Suppose an importer declares a transaction value based on invoice. The department feels that the value is low. Can the department reject the value merely because the price appears low? No. The department must bring material. It must bring comparable imports. It must bring evidence of additional consideration. It must bring evidence of related party influence if alleged. It must bring proof of parallel payment if alleged. It must bring authentic documents. It must bring reliable data. It must bring legally admissible material. Without that, a valuation enhancement becomes vulnerable. The invoice price is not untouchable. Customs can question it, but before rejecting it, customs must produce evidence. That is the difference between doubt and proof. An assumption is not proof. If the department assumes that goods must have a higher value because similar goods are generally expensive, that is not enough. If the department assumes that the importer must have paid extra money because the declared value is low, that is not enough. If the department assumes that a foreign supplier would not sell at discount, that is not enough. An assumption is only a mental conclusion. Evidence requires material. Conjecture means a guess. In customs law, guesses cannot create liability. The department cannot say, "Probably the importer paid extra. Possibly the description is incomplete. Maybe the declared value is not genuine." Such language may justify investigation, but it cannot justify final demand. A demand must rest on facts, not possibilities. Unverified data is also not reliable evidence. For example, if the department relies on market data, internet prices, overseas information, third-party declarations, database entries, or printouts, the question is the data authenticated? Is the data comparable? Is it related to the same goods? Is it from the same time period? Is quantity comparable? Is commercial level comparable? Is the source reliable? Was the importer given a chance to rebut it? If these questions are not answered, the data may not be legally strong enough. Statements recorded during investigation may be relevant, but they are not automatically conclusive. If a statement is retracted, contradicted, unsupported by documents, or not corroborated by independent evidence, the department cannot blindly rely on it. A statement must be tested. Was it voluntary? Is it supported by documents? Is it consistent with invoices, bank records, contracts, ledgers, import documents, or correspondence? If not, the statement alone may not sustain a serious customs demand. Incomplete analysis is also dangerous. For example, in valuation cases, the department may pick one high-value import and compare it with the importer's goods. But are the goods identical? Are they similar? Are they imported at or about the same time? Are the quantities comparable? Is the country of origin same? Is the brand same? Is the model same? Is the commercial level same? Are there discounts, stock clearance, old stock, damaged goods, bulk purchase, or special commercial reasons? If these factors are ignored, the analysis becomes incomplete. An incomplete analysis is not proof. Evidence must be relevant, authentic, reliable, admissible, and probative. Why a customs show cause notice may fail due to violation of natural justice. A show cause notice is not valid merely because it is issued by the department. It must give the noticee a fair and effective opportunity to defend. Natural justice rests on two fundamental rules. First, audi alteram partem, hear the other side. This means the notice must clearly state the allegations, disclose relied upon documents, give reasonable time to reply, and provide a real opportunity of personal hearing. Second, nemo judex in causa sua. No one should be a judge in his own cause. The authority must act fairly, without bias, with an open and independent mind. Justice must not only be done, it must also appear to be done. If relied upon documents are withheld, statements are not supplied, cross-examination is denied, personal hearing is ineffective, adverse material is not disclosed, or the authority acts with a closed mind, the proceedings become legally vulnerable. The message is simple. Fair hearing is a legal right, not a formality. In customs law, power must be exercised fairly. No fair hearing means no valid demand. Why a customs show cause notice may fail when it is vague or without specific particulars. A show cause notice is the foundation of the entire adjudication proceeding. It must clearly tell the importer what the case is, what facts are relied upon, what legal provisions are invoked, what evidence supports the allegation, and what demand or penalty is proposed. A vague notice saying only that goods appear undervalued, classification appears incorrect, or suppression is evident is not enough. The notice must answer basic questions. What is wrong? Why is it wrong? Which provision is violated? Which documents are relied upon? What amount is demanded? What penalty or confiscation is proposed? If the importer cannot understand the case against him, he cannot effectively defend himself. That is why an uncertain accusation is no accusation in law. A vague SCN violates natural justice, prevents proper defense, and may make the proceedings legally defective. The key message is simple. No particulars, no proper defense, no clear allegation, no valid proceeding. When the adjudication order travels beyond the show cause notice, the order is not sustainable. A show cause notice is not just a formality. It is the foundation and boundary of the entire adjudication. It tells the importer what allegations are made, what evidence is relied upon, and what case has to be answered. The adjudicating authority must remain within the four corners of the show cause notice. If the notice alleges undervaluation, the order cannot confirm demand on a new ground of classification. If the notice proposes confiscation under one provision, the order cannot impose confiscation under a different provision never mentioned. If fresh evidence or new legal grounds are used, they must first be disclosed, and the importer must get a proper opportunity to respond. No one can be condemned on a ground that was never put to him. The key principle is simple. The show cause notice is both a sword and a boundary. It gives power to adjudicate, but it also limits that power. Customs cannot begin with one allegation and end with another. So remember, show cause notice sets the boundary. Adjudication must stay within that boundary. Order beyond SCN is legally unsustainable. The show cause notice is void ab initio due to Rule 12 not followed, and no contemporary evidence is explained in detail in earlier video of title customs valuation. The legal advantage every importer should know. The link of YouTube is provided in the description of this video. A show cause notice under the Customs Act is not a routine forwarding letter. It is a statutory act. The proper officer must independently examine the facts, evidence, legal provisions, limitation, jurisdiction, and the need to initiate proceedings. If and show cause notice is issued merely by copying an investigation report, audit objection, dry proposal, intelligence note, or standard template, without independent consideration, it becomes legally vulnerable. The officer cannot simply say, approved, issue show cause notice, or proceed accordingly. Statutory satisfaction cannot be borrowed from another officer. It must be personal, genuine, reasoned, and based on relevant material. A mechanical show cause notice shows absence of real decision-making. It may ignore documents submitted by the importer, overlook binding precedents, use identical allegations, or reproduce statutory language without factual analysis. The key message is simple. Power without application of mind is not lawful exercise of power. A customs show cause notice must reflect independent satisfaction of the proper officer. If the notice is mechanical, the proceedings may fail at the foundation. Thank you for watching Customs and GST Advisory channel of Customs GST.com. The key takeaways are clear. A valid SCN must come from a lawful authority. Power cannot be exercised beyond statutory competence. A time-barred demand cannot be sustained without legal foundation. No evidence or violation of natural justice can destroy the proceeding. And if the notice is vague, mechanical, or the final order goes beyond the SCN, the entire action becomes legally vulnerable. Most importantly, a show cause notice must reflect independent application of mind. Copy-paste notices are legally weak. Statutory satisfaction cannot be borrowed, and mechanical proceedings may be set aside. So always remember, power without application of mind is not lawful power. If you found this series useful, please like, share, subscribe, and press the bell icon. For more legal insights on customs and GST, visit Customs.com. Thank you once again for watching, and we will meet again with another important topic very soon.